Good afternoon. This is the final round of the Nuremberg Moot Court. I will start with introduction of the bench, then I will ask the parties the appearance, starting with the prosecution, then defense, and then I will give floor to the parties, starting with the prosecution, then defense, to present the submission to the court. So let me start to introduce the bench. On my far right is Judge Ušacka, on my right is Judge Reinhardt. On my left right is Judge Muhamedov, Judge Rakvic, and I am Ivana Hrdličková. I would like to ask the prosecution for the appearance.
Good afternoon, Your Honours. My name is Nana Pal, and alongside me is my co-counsel, Ms. Violet, and we represent the prosecution.
Thank you. Defense, please, can you present yourself?
Your Honours, my name is Kanishki, and I shall be representing the counsel of the defense with the assistance of my
Thank you. So you have 30 minutes to present your submission to the court. Last 5 minutes you can reserve for rebuttal and rejoinder. So I would like to ask the prosecution with presenting your submission. The floor is yours.
Good afternoon, Your Honours. May it please the court. I will speak for 15 minutes, while my co-counsel will speak for 10 minutes. Your Honours, the case at hand concerns the enforced disappearance of 70 individuals since over 10 months ago. Enforced disappearance is a serious violation of human rights. It disappears the victims, denies the event, leaving them susceptible to the possibility of unfair or inhumane treatment shielded from the public eye. This court should not condone this series of disappearances. The prosecution will show that at this stage, there are reasonable grounds for the case to proceed, and we make 3 submissions. First, that this court has subject matter jurisdiction, as the enforced disappearances meet the requirement of a crime against humanity. Second, that this case is admissible as the defense has failed to prove the existence of ongoing investigations on the national level, and separately, that this case is sufficiently grave. And third, that there are reasonable grounds to believe that the accused, Mr. Vega, is individually liable for ordering this crime. I will address the first 2 issues, while Ms. Hua will address the last issue. On the first issue of jurisdiction, this court has jurisdiction, as there are reasonable grounds to believe the enforced disappearance has been made out. We say first that the act of enforced disappearance is clear. The NIO task force arrested all victims on 17 September 2018, and when information was requested of them, the government did not respond. Separately, we also submit that the intention to remove the victims from the protection of the law is also clear on the facts. So in the case of in the ICC case to authorize investigations into Burundi, this court noted that intention can be inferred from the manner in which the victims were deprived of their liberty. And in that case, the court considered that as the Burundi authorities arrested individuals without a judicial warrant, placed them in unofficial prisons, this removed them from access to judicial remedies and legal assistance. Even in the case of Goiburu and Peru, even the mere non-registration of the victims in official records was also considered by the Inter-American Court of Human Rights to be a removal from the protection of the law.
On that point, do you rely on the intention to remove, or how do we treat the alternative submission as to refusal to register or give information?
Madam President, if I may, also on this passage of yours, you referred to the Inter-American Court. Can you convince us that this court should take the account of another jurisdiction, whether Inter-American Court or European Court of Human Rights or African Court of Human and People's Rights into account? Thank you.
Thank you, Your Honor. So first, to answer Your Honor's question on the status of jurisprudence from other courts, we would say that as this court has only seen 2 cases involving enforced disappearance, first, the investigations into Côte d'Ivoire, and second, the case of Burundi, and that these 2 are at very preliminary stages of authorizing into investigation, that cases from other human rights courts would be persuasive in demonstrating where there was a removal from the protection of the law.
Correct, but this is International Criminal Court. Why should we engage in dialogue with human rights courts?
Your Honor, under Article 21.3 of the Rome Statute, this court must apply and interpret law in accordance with internationally recognized human rights norms, and we say that the practice of these courts are persuasive for this court to consider. Now, moving on to Your Honor's question on the refusal to provide information. Your Honor, that is indeed the case. We are saying that not just the refusal, but the whole manner in which the detention, the supposed trial, as well as imprisonment that took place, show a clear intention to remove them from the protection of the law.
So can I just begin? The refusal to provide information is then a peripheral subsidiary submission or a main submission?
We would say that because of these actions, we can see that there is an intention to remove them from the protection of the law.
Thank you.
So first, the NIO has secretly detained the victims pre-trial for 13 days when their own criminal procedure code only provides for 72 hours. And furthermore, the secrecy of this detention does not allow for judicial supervision and prevented the families from raising remedies such as a review on the grounds of the detention. Second fact, the manner in which these trials were conducted also give good reasons to believe that these victims were removed from the protection of the law. In the case of Petruzzi and Peru, again an Inter-American Court of Human Rights case, the court took issue with the lack of legal certainty because the charge allayed against the victims there was the vague charge of treason, which could cover a wide variety of actions. And we say that similarly in this case, the charge here was vague. It was a vague charge of endangering national security without providing information as to what criteria would fulfill endangering national security. Furthermore, in our case, these individuals were summarily tried. The meaning of summarily means instant and without a legal process. They managed to convict all 70 individuals for such a serious crime within 1 day, and we have no information on what body tried them, if they had access to legal counsel, or if they were even informed of the charge allayed against them. And we say that this is a deprivation of their right to a fair trial, as well as their right to legal certainty. And last, the NIO, of course, kept the place of imprisonment a secret, and there are no guarantees that the victims were treated humanely. Hence, we submit that the elements of enforced disappearance are made out on the facts. Next, we also submit that these disappearances were a systematic attack. Your Honours, the purpose of the systematic requirement is to identify the organized use of crimes, which causes such severe harm as to elevate these crimes to a matter of international concern. And so in the case of Prosecutor in Katanga, the court noted that the level of organization for a plan is if it would result in a regular pattern and a continuous commission of crimes. We say in the present case that there was a 5-stage plan where there was a clear pattern of conduct. Individuals were arrested. Efforts were then made to assume some of their online personalities. They were all subject to an unknown procedure convicting them of such a serious crime within 1 day. They were then put in secret NIO facilities. And last, the NIO and Mr. Vega were collectively silent to any request of information by the families of the victims, leaving them in a state of anguish as to the status of their loved ones. Your Honor, these 5 stages were repeatedly applied on these 70 persons, possibly spread out all over Schwarzwald. And forced disappearance is a continuous crime. And as we speak, the victims are still disappeared. Their families are still wondering if they are still alive.
Counsel, Madam President, if I may. Counsel, how do you define continuity? Because I think that the events you're talking about, they transpired in a very short period of time. So how can you apply the test of widespread and the test of systematic, as well as the test of regularity on the events which were so much confined, condensed in time?
Your Honor, our submissions rest solely on systematic, and so just to clarify, we are not submitting on widespreadness. Yes, so in response to your question, we do agree that these attacks took place on one day, but we say that this court should not just dismiss it merely because it happened in one day. Many attacks take place in one day. In the case of Katanga, the village of Bogoro was attacked in one day. What we should focus on is the high level of orchestration of the 5-stage plan, as well as the lasting impact that remains till today for these victims who are still disappeared. Hence, we submit that this court has jurisdiction, as there was enforced disappearance, and it was a systematic attack. Your Honor, moving on to the second issue of admissibility. This case is deemed admissible once the court is satisfied on its jurisdiction, and the burden hence rests on the defense who is challenging admissibility to prove otherwise, and this was noted by this court in the case of Prosecutor and Courtroom. Your Honor, there are 2 possible grounds which we posit the defense may attempt to challenge admissibility. First, where there is an ongoing investigation on the same case, and second, where the case is insufficiently grave to elevate ordinary crimes to a matter of international concern. We say that these 2 grounds are not made out. For the first ground, the case is inadmissible if it is being investigated on the national level. To prove that there is an investigation, the defense must show evidence of concrete, tangible, and progressive steps. And Your Honor, this standard is necessary for this chamber to assess if the steps taken by the state overlap with the case at hand. And until this has been shown, this court should not decline its jurisdiction because there is the possibility that the crime may go unprosecuted, which may lead to impunity.
Counsel, again, if I may. The facts of the case, the independent body is established on the 3rd of January, and on 1st of February, just less than 1 month later, Mr. Vega is sent it over to this court. 1 month, is it enough to show the seriousness of intentions of that investigative body to pursue its business?
Your Honor, our first response to that is that whether a case is admissible is determined at the time at which it is brought. And so we say if the defense has chosen to bring its claim at such a time where it has no evidence, then we say that the court cannot find it to be inadmissible. But in any event, we would say that even till today, there is no evidence of any investigative steps that are taken by Schwarzwald for this court to determine on its own motion that this case is inadmissible. Your Honor, yeah.
I would like to continue question of my colleague and to return to the Article 17. So, what do you understand by the case is being investigated and prosecuted? What does it mean?
Your Honor, we note that Article 17 states it in the disjunctive, which means that the investigation so what the defense has to show does not actually have to show a prosecution, but that there are actually steps taken to investigate Mr. Vega. And we say that on the facts, there are no such facts. First, this court has consistently required in previous cases the type of evidence to be either, if the person challenging admissibility claims that there has been witness interviews, there must be witness transcripts. If there were evidence of revisits into criminal sites, then there must be reports of these visits. And we say that here, there is no evidence of these common investigative steps. Furthermore, all the defense may claim is that an independent body has been set up. And Your Honor, we say that this is irrelevant. What is at point as an issue is whether the body has taken any investigative steps. And we say that there is no actual proof of such steps. First, this court does not actually have a report which this body has been instructed to produce, and so we cannot ascertain its content. Furthermore, the promise of a future report cannot be proof of existing investigative steps. The report may be a summary of mere assertions without more, Your Honor. Second, the instructions given to the body, the instructions given to the body is also not sufficient proof of investigative steps. The instructions first state the legal provision, but we say this is insufficient until we know the exact factual grounds which are being investigated. We say that this is important because an investigation into kidnapping may not cover a considerable portion of the conduct that is assessed before this court. It is likely that it will not cover the impropriety of the trials, as well as any possible inhumane treatments in the course of the imprisonment. Furthermore, the instructions also refer to an abstract entity, the NIO, and we say that this is not proof that investigations were carried out against Mr. Vega. Your Honor, I see, do you have a question, or you look as if, okay.
Don't interpret the looks. I'm listening. I'm carefully listening.
So, Your Honor, in the same 7 months while the Office of the Prosecutor has gathered evidence, nothing has been heard of from the independent body. The state has not specified their suspects. They have not secured the release of the victims who lie somewhere within their own grounds. And to deem this case inadmissible on such tenuous grounds would be premature and may lead to impunity. Your Honor, in the interest of time, I will just summarize my last point on sufficient gravity. This court noted in the case of Prosecutor and Charles Blay Goudet, the gravity is not just concerned with the number of victims, but also with the aggravating circumstances involved. In this case, we point to the following aggravating circumstances. Your Honor, the 5-stage plan targeted 30 refugees who were already vulnerable and subject to physical and verbal attacks. And in a situation like this, the NIO has elected the most convenient way to just disappear them without a trace. This blatant violation of international human rights norms has attracted the attention of various human rights organizations whose cries have fallen on deaf ears. And Your Honor, while there were 7 direct victims, we also point to the indirect victims here, the families of these victims who still wait every day for the return of their loved ones. Your Honor, the only way to bring justice to this situation is to have the prosecution occur before the ICC. And the prosecution has identified the person most responsible for this crime. I will hand the floor over to my co-counsel, Ms. Huang, to address this court on the issue of Mr. Vega's criminal responsibility. Thank you.
Good afternoon. May it please the court. My co-counsel, Ms. Tan, has shown the court that a crime within the jurisdiction of the court has been committed, and that the chamber should exercise the jurisdiction. We now move on to the person responsible for the crime, Mr. Vega, the head of the National Intelligence Office, the NIO. The prosecution will now show that there are reasonable grounds to believe that Mr. Vega is liable under Article 25(3)(b) of the Rome Statute. The prosecution will prove the following 4 elements. That first, Mr. Vega is in a position of authority. Second, Mr. Vega instructed Ms. York to perform the acts in the execution of which the crime was carried out. Third, the order had a direct effect on the commission of the crime. And lastly, Mr. Vega was aware that the crime of enforced disappearance will be committed in the ordinary course of events. As it is not disputed that Mr. Vega is in a position of authority, I'll focus on the last 3 elements. Turning to my first submission, that Mr. Vega instructed Ms. York to perform acts in the execution of which enforced disappearance was carried out. Your Honors, Mr. Vega is the head of the NIO and Ms. York's superior. He gave direct instructions to Ms. York to take all necessary actions to deal with the refugees. While the defense may contend that there is no specific order, we say that we should look at the facts in totality. That firstly, the instructions were given in light of the expert report, which at paragraph 12 recommended against an open arrest. Furthermore, he asked her not to attract public attention, and we say it is implicit in his instructions that the manner of commission should be discreet and there should be a secret arrest. Subsequently, we know that Ms. York proposed the 5-stage plan at paragraph 14 to disappear the individuals, and there are reasonable grounds to believe that this proposal was in fact communicated to and approved by Mr. Vega.
Can you please more elaborate the term of all necessary measures? What exactly you can prove on that? What exactly it could mean?
Your Honor, from the term to take all necessary measures, we see that Mr. Vega is suggesting that they are entitled to take extreme measures, such as in the present case where they disappeared 70 individuals. Moreover, our case is not built on his instruction alone. Subsequently, there are reasons to believe that Mr. Vega knew of and approved the 5-stage plan for the following reasons. That firstly, Ms. York received direct instructions from Mr. Vega. It is improbable there is another person Ms. York could have proposed the plan to.
So do you consider that the term all necessary measures could mean also illegal measures implicitly?
Yes, exactly, Your Honor. It could include illegal measures. And moreover, we point at the facts that the plan entailed the use of substantial NIO resources, such as personnel, as well as detention facilities throughout Schwarzwald. It is inconceivable that this could have been carried out without Mr. Vega's approval, as it entailed such substantial use of resources and had to be mobilized within 2 days.
And would you have any jurisprudence concerning the generality of the instruction or need for specific instruction?
Your Honors, jurisprudence has consistently held that the order can be implicit or explicit. And for instance, in the ICTY case of Galish, it was found that even though there was a lack of direct evidence of a written order, nonetheless, because of Mr. Galish's position as the head of the military corps, as well as his strict control over the shelling activities, the court found that there is ground to show that he had ordered those shelling activities. And therefore, there is no paucity of jurisprudence that shows that we cannot infer an order from the facts. Yes, Your Honor.
You're inviting us to draw an inference from the facts. Can you help me as to how we'd approach your application looking at inference from the facts? How would we approach that as judges? Inference.
Your Honor, at this stage of proceedings, the evidentiary standard is reasonable ground to believe. What that entails was explained in the case by the appeals chamber in the al-Bashir case at paragraph 31. In that case, the court held that it does not require the prosecution to prove that the genocidal intent of al-Bashir was the only reasonable inference, because that would be akin to requiring the prosecution to prove beyond reasonable doubt.
Thank you. You've answered the question.
Yes. Thank you, Your Honor, for the question.
I'd like to continue also a question of my colleague, yeah? What kind of evidence you have for this standard of proof?
Yes, Your Honor. To address your question, we point to 4 facts shown on the record. That firstly, there is substantial use of NIO resources, such as the personnel, the NIO task force, as well as detention facilities throughout Schwarzwald. And it is inconceivable that this could have been done without Mr. Vega's approval, as Ms. York is only a head of subdivision in the NIO. The second fact is that at the end of paragraph 13...
You are speaking about facts. I am asking about evidence. In order to decide this issue, we need to look to evidence. What kind of evidence you are submitting?
Yes, Your Honor. The evidence we're relying on is also what the parties have agreed on the facts. And we also know that there is no other governmental agency that knew about Mr. Vega's instructions to Ms. York, and that can be seen at the end of paragraph 13. And moreover, Your Honors, he gave an instruction concerning national security. It is inconceivable that 14 days after he gave the instructions, Mr. Vega didn't follow up on what measures were taken. And this brings me to my second point, that these instructions, accompanied by his approval, had a direct effect on the commission of the crime.
So are you saying that Mr. Vega should follow up? That was his duty to follow up his instruction? That's what you are saying?
Your Honor, what we are saying is that it is improbable that he didn't follow up, and therefore he must have known about the five-stage plan. But of course, our alternative argument is that he should have the duty as the head of the NIO to follow up on such an instruction concerning national security. On the last point of specific knowledge, we see that because Mr. Vega knew about the instructions and gave subsequent approval of the five-stage plan, he knew that the crime would be committed in the ordinary course of events. The five-stage plan, as shown in paragraph 14, entailed the secret trials of the individuals, followed by the refusal to acknowledge their whereabouts to their family members. And these are the elements constituting the underlying crime, as my co-counsel has addressed. And therefore, there are reasonable grounds to believe that he had specific knowledge that the crime would be committed in the ordinary course of events. Therefore, Your Honors, we urge this chamber to uphold its jurisdiction and exercise its jurisdiction. 70 victims have been missing for almost a year, and their families are still living in fear and uncertainties. In the meantime, the state of Schwarzwald has failed to show any concrete investigative steps. And Mr. Vega continues to shirk responsibility and deny involvement and feign ignorance. I know that my time is up, but we urge this court to put an end to impunity. May it please the court. Thank you.
Thank you very much. And now I give the floor to the defense to present your submission.
Your Honours, may it please the court, my name is Hanin Shadid and I shall be representing the Counsel of the Defence. Your Honours, I am standing here today on behalf of Mr. Vincent Vega, a man who, just like any other good-natured and dutiful human in such a position, has made his due diligence in order to provide a collective and tranquil social structure, and first and foremostly to ensure the protection of the people of Schwarzwald and with their safety at heart. The Counsel of the Defence shall be challenging the jurisdiction and the admissibility in the case against Mr. Vincent Vega, and shall be ascertaining his criminal responsibility as pursuant to Article 25(3)b of the Rome Statute. I shall be addressing these challenges in the next 25 minutes and shall reserve 5 minutes for rebuttal. Your Honours, the case against Mr. Vincent Vega does not fall within the jurisdiction of this court. The defence does not deny that the case does fall within the temporal and the territorial jurisdiction. However, the defence shall be challenging the subject matter jurisdiction pursuant to Article 5 of the Rome Statute, as any of the acts allegedly committed by Mr. Vincent Vega do not constitute a crime against humanity. Your Honours, as had been established by my esteemed colleagues, that they had gone into the specific elements of the crime of enforced disappearances. However, the defence shall only delve into the contextual elements due to a recent judgment, the decision on the appeals of Ruto and Sang against a decision of Pre-Trial Chamber 2, in paragraph 28, where it held that it was observed by the Pre-Trial Chamber that challenges relating to the contours of the crime do not fall under the jurisdictional challenge and are instead to be addressed at the trial stage. And right now before this court, we are still at the pre-trial stage.
Madam President, if I may. Counsel, are you aware of a less than 4-month-old decision of pretrial, of the second pretrial chamber of this court on the situation in the Islamic Republic of Afghanistan? Are you aware of that decision? Counsel, can you adapt, convert the argument of pretrial chamber 2 in that decision to prove that pursuance of the case against your clients would be against the interests of justice? Thank you.
Could you rephrase your question, Your Honor?
I cannot.
Your Honor, the Counsel of the Defense is aware that there is, for example, a dissenting opinion that the contextual elements are both elements of the crimes relating to the nature and jurisdiction. It relates to the contextual elements, and also it is jurisdictional in nature, and therefore the court would not exercise a jurisdiction over the underlying acts in the absence of looking into these elements. However, the defense is of the view and does agree with this decision, not delving into the specific elements, as this would still need, if we were to address it at this stage, there would be nothing to establish at the trial stage.
Thank you.
If I may proceed.
Can I just come in with a supplemental there? Has any appeal chamber at the ICC approved of the pre-trial chamber's view that you've quoted?
Yes, Your Honour. In the appeals chamber, in the case of Ruto and Sang, it had been appealed from the trial chamber. It was they were appealing the policy requirement, and the appeals judgment did hold that it would not be required to even look into these elements due to the fact that this should be held at the trial stage.
Don't go further. It was my misunderstanding. Thank you.
Thank you. If I may proceed.
Please proceed.
Your Honours, the contextual elements of crimes against humanity are not established. For an act to constitute a crime against humanity, it would need to commit it as part of a widespread or systematic attack and pursuant to a state or organisational policy. Firstly, the attack is not of a systematic character. As the pre-trial chamber in the situation of Kenya held, systematic is often expressed through patterns of crimes in the sense of the non-accidental repetition in the occurrence of the crimes on a regular basis. In the case at hand, the alleged detentions took place on the 17th of September, while the alleged trials took place on the 30th of September, according to paragraphs 15 and 16. However, bearing in mind these dates and the short-term occurrence of the events, it cannot be held that this could be considered a pattern or a repetition in the unfolding of the events. This renders this attack far from systematic and lacking an organised nature.
Counsel, can you please enlighten me? If I am not mistaken, then allegedly all members of a particular group have been disappeared. If all members have been disappearing, can anything be more systematic than that?
Your Honour, the defence realises that, for example, an existence of a plan would be indicative of systematicity according to the contextual elements. However, this does not deny that systematic does require an organised nature, and even though the acts may have allegedly occurred implying a systematic nature, that does not mean that they might not have existed in a random manner or in pursuance by another individual besides Mr. Vega. If I may proceed. Moving towards the final contextual element, the defence contends that the attack was not in furtherance or pursuance to a state or organisational policy. A policy requires only that a state or an organisation encourages the attack either actively or passively. It shall be made clear that the policy would need to be to commit a crime against humanity. However, the defence contends that even if the NIO had allegedly carried out its acts, it would need to, in the least, represent the NIO before even representing the state. Nonetheless, it is understood through Mr. Vega's acts as head of an official state agency, according to Clarification 1, the policy by which the state stands. Mr. Vega, based on paragraph 13, had issued his instructions to prevent further instability for the sake of national security, and also the government itself did communicate prior to Mr. Vega's orders its concerns over a civil war breaking out. This would reaffirm the state and Mr. Vega's policy to maintain national security and stability. And the NIO task force, although it could be held subordinate to the state and may be held responsible, they cannot be deemed to represent the state policy. This was also mirrored by the pre-trial chamber in the situation of Kenya, where the chamber held that even if the Kenyan police did actually commit crimes against murder against Kenyan civilians, this did not equate to the police representing the state policy. This is what the pre-trial chamber had established in the Kenya situation.
Madam President, if I may. Counsel, can you direct us to any jurisprudence of other sister tribunals and courts where the issue of extent to which the means would justify the aim was tested, in particular regarding the survival of a nation, not just stability of the nation, but maybe survival of the nation? Can you direct us to jurisprudence of the courts who discussed that matter? Thank you.
Your Honours, we can look into, for example, the Bagbo case, where recently Mr. Bagbo was acquitted, and he had instructed to take necessary measures to prevent the marches on the RTI. He had instructed to take the measures for fear he had instructed the FDS members to maintain public order, and it was established by the trial chamber that this ultimately led to a commission of crimes. However, due to the fact, following the acquittal itself, Mr. Bagbo, looking at his orders, even though they were to take necessary measures, it didn't warrant that this was to commit a crime, but more so to maintain the public order of Côte d'Ivoire.
Was survival of the nation at stake in Gbagbo case?
Your Honour, it wasn't a survival of the state, more so Mr. Bagbo was concerned about the chaos that would entail following the post-election crisis.
Okay, thank you.
And how would you interpret in this case the term all necessary measures? What exactly you think that it could mean? Is it limited only to lawful, or it could be also extended? How would you interpret it?
Your Honour, the Council of the Defence is of the view that even though necessary measures may entail any measures, we still need to be attentive that it is only the necessary measures, and we need to take into account the surrounding context. As previously established, Mr. Vega had been from the government. It was communicated to him the concerns of a civil war breaking out, and following this, Mr. Vega did commission himself to a group of experts to look into the state of Schwarzwald, where it held that high risk of radicalization was prevalent, and open arrest would result in further instability. In light of this, we can see how this would not, Mr. Vega's orders would not actually warrant a commission of crimes, especially in light of the fact that we have no knowledge of how Mr. Vega's instructions were actually interpreted to the NIO task force.
And don't you think that, or do you think that was his duty to follow up his instructions? Specifically, he said all necessary measures, so to be sure that it's limited the way you mentioned.
If I understand your question, Your Honour, are you asking that he should have interfered following the
Yes.
acts? Okay. Your Honour, in the case at hand, the pre-trial chamber is looking into if there are reasonable grounds to look into criminal responsibility of Mr. Vega under Article 25.3b. If it were that we were looking into Article 28, for example, we may take into account that Mr. Vega would have the duty to interfere and therefore prevent and punish the NIO task force or Ms. York for committing the crimes.
Counsel, can you just fix some holes in my knowledge of geography? Whereabouts is Schwarzwald?
In reality, Your Honor?
Where's that?
In reality?
Yeah.
Well, it's just a mountainous region. It's a mountainous region in Germany, I believe.
Name is very German, is it? Carry on.
If I may proceed.
We appreciate your knowledge. Thank you.
If there are no inquiries, I shall now move on to challenge the admissibility of the case. The defence shall test the complementarity and the gravity under Article 17(1)a and d of the Rome Statute. With regards to complementarity, the Council asserts that there are, in fact, ongoing investigations in the state of Schwarzwald. And it may be a contention that due to the fact that the state did not take any investigative steps prior to the proprio motu investigations, that there existed inactivity in the state of Schwarzwald. However, based on the contention of the appeals chamber in the Katanga judgment, it held that a factual situation on the basis of which the admissibility of a case is established is not necessarily static but ambulatory. This would entail that the admissibility of a case must be determined on the basis of the facts occurring that exist in the proceedings concerning the admissibility challenge. In our case, an admissible case may become inadmissible and vice versa. Accordingly, although the prosecutor had initiated investigations on 10th December 2018, the government of Schwarzwald did announce the establishment of an independent body to look into the alleged disappearances prior to the admissibility challenge. This would warrant that the state is, there are in fact national investigations in Schwarzwald.
So do you think that according to the Article 17, the independent body to look, to investigate the allegations is, according to Article 17, even if it's not clear what is the outcome of this independent body?
Your Honour, we can hold on to the Sanusi judgment where it holds that for a case to be inadmissible pursuant to Article 17(1)a, that it must cover, the national proceedings must cover the same case. Thereby meaning it covers the same suspect and substantially the same conduct. In the case at hand, the investigative body did look into the allegations of kidnapping allegedly committed by the NIO. Therefore, this would encompass Mr. Vega as head of this body. With regards to substantially the same conduct, the Rebuttal judgment held that where there is a large overlap between the incidents brought before this court and during the national proceedings, that this would substantially cover the same conduct. In the case at hand, the investigative body did initiate its investigations prior to the admissibility challenge and looking into the allegations of the disappearances that took place on 17th of September. More so the incidents that underlie the incentive towards communicating to the prosecutor to initiate the proprio motu investigations can be said to be the exact same incidents, and accordingly the case and the conduct would be one and the same. If you allow me honours, I shall proceed. Due to a lack of time, the Council of the Defence shall look into and address if there are reasonable grounds to consider that Mr. Vega is criminally responsible pursuant to Article 25(3)b. As stated by the pre-trial chamber in the decision pursuant to Article 61(7)a against Mr. Ntaganda, a person would be held criminally responsible for ordering a crime if they fulfill the following conditions. First, they would need to be in a position of authority. Secondly, that they instruct another person to commit a crime that actually occurs or is attempted. Thirdly, that the orders held a substantial and direct effect upon the acts. And fourthly, that the person is at least aware that the crimes would be committed as a consequence of the implementation of the orders. The defense does not deny that Mr. Vega is in fact in a position of authority and that he did instruct Ms. York. However, we cannot deduce that his instructions were criminal in nature. Mr. Vega's explicit instructions were to take all necessary measures for the sake of national security and for fear of a civil war breaking out. His orders did not direct to detain, assume identities, or try individuals. And moreover, we cannot hold on to necessary measures in order to that would warrant a commission of crimes due to the fact, as established previously, that we have no knowledge of how Mr. Vega's instructions were actually interpreted to the NIO. Therefore, this would require a huge leap of faith from the chamber to infer from this that Mr. Vega did actually license to engage in a criminal conduct.
Counsel, let me probe, with your permission, can I probe your knowledge on a broader scale? What is the meaning attributed to, quote, all necessary measures, end of quote, by the UN Security Council?
Your Honours, the Council of the Defence has no response to this question,
thank you.
But we shall
Thank
work
you.
on it during this session.
Thank you. Withdrawn.
If I may proceed?
Please proceed.
As for the direct effect an order has upon a crime, it would need to be established a degree of causality between the orders and the acts.
Don't worry.
However, as concluded recently by Judge Jeffrey Henderson in his written opinion for the Bagbo acquittal, that at no point is there evidence that the physical perpetrators in that case acted upon Mr. Bagbo's orders. And also, Judge Jeffrey Henderson rejected the argument that the existence of a spatial and temporal proximity with regards to the orders would actually entail a direct effect upon the orders. Looking at this, looking at the facts of the case, Mr. Vega did issue his orders on the 1st of September 2018, while the NIO had allegedly carried out its acts on 17 September 2018. This was approximately 2 weeks in order to actually carry out the acts. Taking this into consideration, we cannot presume that just because the acts had occurred within a close time frame, that the NIO had actually directly acted upon Mr. Vega's orders.
And do you have any evidence, or could you have any evidence what else could cause the act if it was not the order of Mr. Vega?
Your Honor, we would look into also the surrounding context to see if the orders held a direct effect. If the court deems that the spatial and temporal proximity is not sufficient, we can also look into the argument of the prosecutor with regards to the chronological argument in this case. And even if, for example, as established that Mr. Vega did issue his orders on the 1st of September and the NIO task force did carry out its acts on 17th of September, this would still be a relatively long time before actually acting upon orders, and so forth. From this, we cannot take into account that even based on the spatial temporal proximity, that the NIO task force did actually directly act upon the orders of Mr.
Is there any supporting jurisprudence you can quote about the timing? Is it a relatively long time between the order and the act?
Your Honor, we can hold on to the written opinion for Judge Jeffrey Henderson on the Bagbo acquittal, where even when, for example, Charles Le Goudet had ordered the youth in Yopougon to mobilize them against the protesters in the RTI march, he had instructed on the he had instructed on the 15th of February, and the acts themselves did actually take place on the same day and until the 20th of February. And even though this occurred, the Chamber still concluded that the orders could not have held a direct effect upon the orders.
Are you asking us to entertain the possibility that 70 individuals were seized, arrested, and taken into detention as a matter of coincidence?
Your Honours, the Counsel of the Defence is not requesting of the Court that it is due to complete coincidence. However, the Council is still establishing that Mr. Vega's orders, particularly, don't hold direct effect upon the orders. It may be contended that there was a plan, or that any other governmental official may have planned an attack, and that it may have allegedly been carried out. However, the Council of the Defence is of the interest of disproving that Mr. Vega's orders had held direct effect upon the acts. If I may proceed. Nevertheless, with regards to the last requirement, the knowledge requirement, the facts of the case do not point towards or even imply that Mr. Vega possessed the necessary knowledge that a commission of crimes would have occurred as a consequence of his orders. We can also, again, hold on to Judge Jeffrey Henderson's opinion in the Bagbo case, where it would need to be, the criminal responsibility would need to be foreseeable at the time of issuing the orders. It would need to be an inevitable result of the orders and in light of the surrounding context. In the Bagbo case, there were no relevant instances between 2000 and 2010 where instructions were issued to deploy the FDS members to ensure public order, and that were actually connected to the Bagbo case. Similarly, in our case, there existed, and based on the facts of the case, that a governmental official had actually instructed to prevent further instability, and that actually led to a commission of crimes. According to this, it cannot be held that Mr. Vega could have foreseen that enforced disappearances would actually occur as an implementation of his orders.
You've referred in the last minute to the mens rea of knowledge, and you've now just referred to foresight. Which is it?
Sorry, Your Honour?
In terms of the mens rea, you've referred to knowledge of circumstances happening, and you've just talked about awareness or foresight of circumstances happening. Which do you invite us to apply?
And you can have additional 1 more minute.
Okay, thank you. Your Honour, with regards to this requirement, it isn't complete certainty. It would need to be virtual certainty. The condition holds or states that the person is at least aware in the ordinary course of events that a crime would be committed.
Thank you. You've answered the question.
Thank you. If I may proceed. For the foregoing arguments, the Counsel of the Defence would like to respectfully request of this Court to consider that, firstly, the case against Mr. Vincent Vega does not fall within the jurisdiction of this Court; secondly, that the case is inadmissible; and thirdly, that there are no reasonable grounds to believe that Mr. Vega is criminally responsible for ordering a crime pursuant to Article 25(3)(b). Thank you, Your Honours. It was a privilege to present before your Honourable Court and in Historical Room 600. Thank you.
Thank you very much. Would the prosecution take the opportunity for 5 minutes rebuttal? The floor is yours.
Your Honours, may it please the Court. The defence has made light of human rights abuses, but the prosecution says the ends do not justify the means. The prosecution will raise 3 points in rebuttal to show why the defence challenge must fail. On the first point, the defence challenges that there is an absence of state policy But on the other hand, they said there was a policy to address national security threats. So clearly, there is an implicit concession that there was indeed a policy. And even if Mr. Vega had exceeded his mandate, we note under Article 7 of the Articles on State Responsibility that this will be still attributable to the state, even if he acted ultra vires. On the second point of admissibility, the defense said there was an investigative body that was independent. However, we say that a promise of future action does not meet the standard of concrete, tangible, and progressive steps required at this stage. Listen to the silences. They did not mention any witness testimony, any interviews. They did not specify who this investigative body is investigating. Therefore, there is only a promise of future action. And in the words of the court in the case of Gaddafi, the contour of the investigation is unclear, and therefore this case should remain admissible. On the last point, Your Honor, the defense relied on the case of Gbagbo, but we say for 2 points. First is that this case is still upon appeal. And second, the case in Gbagbo is clearly different. The judge, the defense mentioned, said there is no evidence that the physical perpetrators were affected after they heard the speech of Mr. Laurent Gbagbo. But it is different on our facts for 2 reasons. Firstly, there was a proposal initiated by Ms. York to disappear the 70 individuals. If not for Mr. Vega's instructions, Ms. York would not have initiated or created such a plan. Furthermore, the defense did not address...
May I interrupt
Yes, Your Honor.
What is the difference between facts and evidence? You are mentioning both. Thank you.
Yes, Your Honor. There is a difference between fact and evidence. And for the case at hand, we know there is no direct evidence that the proposal was communicated to Mr. Vega. But we know there is evidence of such a proposal and evidence of such a plan. And we say, drawing from these in totality, that the plan was in fact proposed to and approved by Mr. Vega, and therefore he had specific knowledge of that the crime would be committed in the ordinary course of events. Lastly, Your Honor, we note that the defense case is supported by a weak assertion of national security, which is not even mentioned in their own expert report. In any event, the most heinous crimes are often justified under the pretext of noble objectives, but we should pay regard to due process, and this court should not condone such massive violations of human rights orchestrated not by an abstract entity, but by a man, Mr. Vega. Unless there may be a further assistance to this court, this concludes my submissions. Thank you.
Thank you very much. Now I would like to ask defense if you would like to take the opportunity for a joinder, 5 minutes. Please, the floor is yours.
Good afternoon, Your Honours, again. In response to the arguments established by our esteemed colleagues in the Office of the Prosecutor, we would like to submit with regards to the tacit and the lack of intervention that it would require an implicit encouragement. It would have to take into account the state's knowledge of the crimes and the capacity to respond. However, no evidence proves the state's awareness, as the facts of the case do not imply that Ms. York had reported her acts, according to paragraph 17. Mr. Vega also, after the families had come together to voice their concerns, the following day had pronounced that he would look into the investigations on of the allegations of the disappearances. Mr. Vega had assured this would happen, and in accordance with the foregoing argument shall be understood that the state policy is of national security and stability. With regards to the presence of concrete steps and existence of witness protection programs, it was held in the Sanusi admissibility decision that a lack of appropriate witness protection programs in the proceedings in the context of the precarious situation does not result in the inability or the inactivity of the state to carry out its proceedings.
is that relevant here? Witness protection programs, do we have any evidence of that, or does it feature anywhere?
The witness protection programs would demonstrate the existence of some sort of investigative steps from the state. It could be witness protection programs or interviews or interrogations. This is only an example to establish that there are in fact investigative steps occurring in Schwarzwald. And with regards to also if there are investigative steps that existed, the admissibility challenge had been lodged prior to the activities of the investigative body were initiated prior to the admissibility challenge, and as established when looking into the admissibility challenge, the court looks into the factual situation that exists during the time of the proceedings concerning this challenge. At this time, the investigative body was actually investigating the crimes of alleged disappearances by the NIO. Thank you, Your Honours, for your attention.
Thank you very much. The court now adjourn. Judges will deliberate and we will announce the decision due course. So first of all, I would like to start with thanking all of you because you did absolutely excellent job and it was very impressive. And I have to say that judges had very, very difficult task, a lot of discussions, because we are truly impressed by all of you. And it's something extremely promising and positive for the future. However, only one team can win. But before I announce that, I would like also to ask the team, who is the second one, please take it as a motivation and very, very positive feedback from us, because, as I said, all of us were extremely impressed by your performance, by also preparation, your teamwork, and also ability to interact with the judges. It's not always easy to come in front of 5 judges and to answer questions. Some of the questions were not the easy one. And you were absolutely excellent, all of you. However, considering everything, performance in the court, we decided that the winner today is the team of the prosecution. I would like to say a few words to the defense team, because we were impressed by the way you presented the case, by your human approach and ability to interact with the judges. And I think you have potential that it's extremely high. And if there's anything for me personally to perceive positive in international justice, international criminal justice particularly, is you young people, because you are the future and you are doing absolutely impressive job. So thank you very much. Please stay enthusiastic, stay positive and motivated. And before I ask my colleagues if they would like to add something, I would like also to say it's impressive to meet all of you in this historical courtroom. And I think it's such a symbol for international criminal justice. And again, all the best to you. Would you like to add something?
I'd like to say something for other teams at the back or towards the back of the courtroom. You can imagine that over the last few days, the judges collectively have been speaking about this year compared against last year. And I can tell all the teams here that the judges I have spoken to believe that there has been a distinct improvement generally in the presentations that teams have put before us this year compared with last year. And if I can just pick two personal points that I feel have improved, and that is firstly the structure of submissions that are being made. I state the obvious that if you're making a submission on one point, it's subdivided into 4 sub-points, and a deeper analysis of previous case law. And I think you're all to be congratulated on that, and we can only hope that the trend continues.
Okay, so before adjourn, if I may give any advice, please, all the teams, take advantage from being here and stay in touch with each other, because I think the network can help you to improve for the future. Thank you very much. The court is adjourned.